Good afternoon, everyone, and thank you all for joining us for today's presentation. My name is Marissa, an attorney with Legal Aid of North Carolina's Helpline. Today, we have Attorney Bill presenting for us. If you are unfamiliar with the format of this event, first, Bill is going to review a PowerPoint presentation. At the end of the presentation, we will have a question and answer session. If at any point during the presentation you have questions, you can put them in the Q&A box on Zoom or in the comments section on Facebook. We'll review all questions put in the chat boxes during the Q&A session at the end. Please remember that this is a public forum and legal aid is not representing you at this time. Be sure not to reveal personal details about yourself and to keep your questions as general as possible, as we cannot provide any legal advice specific to your individual situation. The session will end when there are no more questions, and regardless of where we are, we will have a hard stop at 4:30 p.m. With all that being said, I'm going to pass it over to Bill to get us started.
Hey, good afternoon, everybody. My name is Bill Gardner. I'm a staff attorney at the Senior Law Project. We're a project of Legal Aid of North Carolina. We provide legal services for seniors who are over 60 years old that also qualify for normal legal aid services. What we do includes wills and advanced directives, which is what we're talking about today. We do elder abuse, which can include financial elder abuse, which we'll touch on a little bit today as well, because it is related to wills and advanced directives. And we also do all other legal aid cases that fit into our case priorities. But again, today we're going to be discussing end-of-life planning documents, also referred to as estate planning documents. There's basically four big ones of these. We've got a will, we've got a financial power of attorney, we've got a healthcare power of attorney, and we've also got a living will. Those are the four we're going to discuss today, and those are the four most common end-of-life documents. First of all, the question is, why should I have end-of-life planning documents? These documents are very helpful to you and your loved ones if you become sick or incapacitated. They also make sure things happen the way you want to at the end of your life and after you pass away. Another thing is they're very helpful if you don't want your biological relatives to be the people you want assisting you in an emergency or inheriting your property after you pass. And the reason for that is, you'll see when we go over these, a lot of the default situations legally, if you don't have these documents, fall back on biological relatives. So if you don't want them to be the ones doing these things, you really have to have these documents in place. So the first one we're going to discuss is a will. A will is a legal document that sets out who inherits your assets after you pass away, and who is the person that manages that property until it's passed on to the people you want it to. It basically says who gets your stuff, and that includes everything. It includes your real estate, your car, money, personal property, everything you've accumulated. It's who gets that after you pass away. Also, one thing people sometimes forget is that it also names who handles the estate and who handles that process after you die. And that in itself can be an important reason to have a will, even if you know just one person that's getting your property, and it's pretty cut and dry. It's still helpful to have a will, just to name the person that can be in charge of doing all that. When does a will take effect? A will is a legal document, but it's not like a contract. It doesn't have any effect in any meeting until actually the day you pass away. So what that means is you can change your will anytime you want to. Theoretically, you could change it every day if you wanted to. As long as you have the mental capacity and you do it the way you're supposed to do, the change you make to your will is what will be legal when you pass away. Just keep in mind that the only will of any that you've done over your lifetime, the only will that's going to be the one that's executed is the last one you did before you pass away. So it's real important to make sure that you update your will as things change in your lifetime. Another important part to remember is that a will itself doesn't change any ownership interest while you're still living. So if you're leaving your car to your best friend, um, when you write that out in a will and you execute it, that doesn't give your friend any kind of ownership interest in that property or anything until you actually pass away. One question that comes up with people is, what happens if you die without a will? A lot of people don't have wills, and a lot of times that does happen. In North Carolina, if you die without a will, your property does not go to the state. I think a lot of people mistakenly think that that does not happen. But what does happen is there's laws in North Carolina called the laws of intestacy, and those guide basically how your assets will go. And it's fairly complex the way they set it out in the statute, but the basic part of it is it's going to go to your closest living family members um, who are alive when you pass away. And that's only going to be legally recognized relationships, which can be an important reason to have a will if you're related to people in ways that are not legally represented, but ways that you have set up. Um, exactly who gets your property depends on a lot of factors, like the makeup of your family, how your assets are titled. But the best way to think of it is it's going to go to your closest relatives. It's going to go to your kids. It's going to go to your spouse if you have somebody surviving you. Um, Also, a will, one thing you can put in there besides dealing with your property is if you have minor children or disabled adults, your will allows you to nominate somebody to become the guardian of your minor child. And what that means is if your child's under 18, you can put somebody in your will that you feel comfortable with taking care of them until they're able to take care of themselves or reach that age of 18. This nomination is not legally binding. It doesn't force the court to do that, but most of the time it's going to be very persuasive to a judge. And absent some unusual circumstance, that's going to be the person that's going to be chosen to be your guardian of your kids. Same way with an disabled adult. If you have a guardianship of a person in that situation, you can nominate somebody as well in your will. Is handwritten wills another topic that comes up? They're also called holographic wills. They are legal in North Carolina. They're valid in North Carolina. Uh, it's really just an option if you cannot get to an attorney to prepare your will right away. If it's some kind of an emergency situation, a temporary stopgap solution, you should always go to an attorney after that emergency is passed to, turn that holographic will into a properly executed will. Um, and the reason for that is because even though a handwritten will is valid, um, it's pretty complex and a little impractical as to how you do that through probate after you die. The will to be valid has to be written entirely in the handwriting of the person making the will. It's got to be signed by that person, and it's got to be found in a proper place, which is like a safety deposit box or with important papers or someone who's safekeeping that. And this last part is the part that makes it somewhat impractical. After death, you actually have to have 3 witnesses to testify as to the handwriting, and you've got to have another witness to testify as to the will being found within those places that are proper. So that means you would need 4 different people to go to court or go to the clerk's office to testify to these things, which can be very difficult to find 4 people to do that and also to get them to come and do that. So these are really reasons why you could use a handwritten will for an emergency, but you really need to get a properly executed one after that. The second document, end of life document, is a financial power of attorney. This is a document people usually use the term power of attorney. They'd leave the financial part off. A financial power of attorney is a document that names someone to help you out in financial and personal business matters. The person who helps you out is called your agent, although a lot of people will call them their POA or power of attorney, but technically they're called an agent. Once that document is executed, and when it comes into effect, and we'll talk about that in a little bit, some examples of what that agent can do for you. He or she can write checks from your bank account, can transfer money from savings account to checking account, deal with insurance issues, car insurance, house insurance, life insurance, They can, talk to county tax offices. They can talk to your mortgage company. Anything related to your financial situation, they essentially step into your place, and the bank and the mortgage company and the tax office will recognize their decisions and choices if they have that proper document. Which leads to this, because it's important to know when a power of attorney takes effect. You really have two ways to do that. The first one is you can do it right away, or you can name an event that will happen in the future that will cause that to come into effect. Most of our clients that I find choose to do it right away. And we do have to explain to them sometimes when they choose that doesn't mean that it automatically means that person can start writing checks or going into your bank account. You still have to be incapacitated for that to take effect. So as long as you're able to make those decisions, even though you've elected for it to be in effect right away, that does not give your agent the power to do that. But some people do put a future event. For example, they may say that it only comes into effect if they become incapacitated. Um, and what I tell people, sometimes if you get a little too complicated with that, then you may run into a situation where there's an issue if you're incapacitated, and it can slow down the process of getting your financial house in order when you are. So a lot of times people choose to do the right away designation. These next two slides are very important. As I said, we deal with a lot of elder abuse situation at the Senior Law Project. And a lot of those involve financial elder abuse, and a lot of those financial elder abuses involve situations where the agent is misusing the person's money. So just keep that in mind. The limits on the agent, they're supposed to, even though your agent is given access to your finances, the agent must use your money in a way that benefits you and only you. And the example we've got is that, the agent can access your checking accounts, they can write checks, but those have to be beneficial to you. They have to be your rent payment or your mortgage payment or your power bill, or medical bills or food, things that benefit you. They can't, write checks to pay for their cell phone bill or pay their mortgage or go on a vacation, at your expenses. And again, we have a lot of cases, well, not a lot, but we do have elder abuse cases where, people have done that. The agents have spent money improperly, and the people find out later, and it just creates a lot of issues. So just a warning, the financial power of attorney creates the potential for financial abuse and exploitation. It gives someone access to your money. They're not supposed to use this access to benefit themselves, but that does not mean it never happens. And the point of all this is not to scare you into getting these documents, because they're very important to do that, but it is to make sure that you're aware that you've got to be really careful on who you pick to do that. It's got to be somebody you trust, somebody who's been honest in their own dealings. That's usually a good indication as well. So just make sure you keep that in mind. There is what's called a guardianship, and we mentioned that earlier, and some people get those confused with the power of attorney. A power of attorney, a guardianship is a legal proceeding where a judge, grants a guardian, a person who's in control of your total situation. And that can be limited or it can be general, but it's a judge making that decision. It's where the person is incapacitated or didn't have any prior power of attorney. A power of attorney does not do that. It is not as involved, and it's different from that. The third document of the four is a healthcare power of attorney. A healthcare power of attorney document names someone to make your medical and healthcare decisions if you are no longer able to make those decisions yourself. And the classic example of that is if you have a car accident and you're unconscious, you're taken to the hospital, and they need to decide whether to do surgery or whether to do a certain kind of surgery. And the medical people need some kind of consent, and they need it quickly. If you've got the healthcare power of an attorney in place, that person can make those decisions. That person can do it very quickly, and it makes the whole process much easier and safer. This slide is listing examples of, what that healthcare agent can do if they are healthcare power of attorney. For example, they can request and review information about your medical condition. They can consent to it being disclosed. They get, they have the ability to pick, to hire and fire healthcare providers, doctors, psychologists, and anybody that administers health services. They can consent to an authorized admission or discharge from healthcare and mental health care facilities. Like I said before, they can consent to surgery, x-rays, anesthesia, and in some cases authorize withholding or withdrawal of like prolonging measures. And then it even can extend to after if you've passed away, they can authorize autopsies or disposition of remains. But the basic way to think of it is that any medical decision you can make for yourself, unless you limit that in your healthcare power of attorney, they'll have the ability to do that. Um, and the actual document of a healthcare power of attorney, it's 3 or 4 pages. It's divided up into sections, and it allows you to limit certain situations. An attorney can go over that with you, or when you're doing that together, can discuss those. But so you can limit what the person can do to a certain extent. Um, and again, financial power of attorney, healthcare power of attorney, the financial power of attorney deals with financial managers, matters. The healthcare power of attorney deals with healthcare and medical matters. One thing to remember is that if you just have one of those documents, it does not translate into you having the other document from a legal standpoint. So if you name somebody your financial power of attorney and you don't have a healthcare power of attorney, and unfortunately something happens to you and you're at the hospital and you're unconscious, the financial power of attorney is not going to give them the ability to make healthcare decisions. And the same thing involves the healthcare power of attorney. If you've given that to somebody and you need somebody to go to your bank and access your checking account or make your mortgage payment or your rent payment, the healthcare power of attorney is not going to give them the ability to do that. So you need to make sure you've got both in place. Then they can be the same person, and that's fairly common from our clients and from most clients. There's nothing wrong with having the same person doing both. When does the healthcare attorney power or healthcare power of attorney take effect? Unlike the financial power of attorney, which can take effect immediately when somebody's incapacitated, the healthcare power of attorney only takes effect if and when you're no longer able to make your medical decisions yourself. So the thing to keep in mind is, as long as you're able to make and communicate your own medical decisions, your doctors are always going to go by what you say and only you. The healthcare power of attorney is not going to take away that ability under any circumstance. The final document we're going to discuss is a living will. A living will is a document that tells your doctors that if you're getting towards the end of your life, you do not want certain extraordinary life prolonging measures. Some people also call this, and in some states it can be called an advance directive for natural death. And there is some interaction between a healthcare power of attorney and a living will, but they are 2 different documents. Just keep in mind that your healthcare power of attorney, you're appointing someone to make your medical decisions if you can't make them yourself. A living will is different because you're in advance expressing your own wishes for certain circumstances that could happen, if you're in that end of life care situation. There's going to be some overlap, but generally it's going to be 2 separate documents. Some people get confused. A do not resuscitate order from a living will. A DNR is a medical order. It's got to come from a doctor. It's not a living will. That's a total medical thing. It's not involved legally or with a lawyer. And just keep in mind that a lawyer cannot give you a DNR order at any point. You can't, that only comes from a doctor. When does a living will take effect? This is different again from a healthcare power of attorney. You can choose the specific triggers in your own living will documents, and those can be if you have an incurable or irreversible condition that result in death within a relative short period of time, or unconscious and to a high degree of medical certainty will never regain your consciousness back, or if you suffer from advanced dementia or other condition resulting in substantial loss of cognitive ability. You can choose any or all of these three triggers. Most people will put all three in there because they're the three situations where you really would want this to come into effect. The final thing to talk about is that all these documents have requirements that have to be done in order to be valid and legal documents. These are by statute, and it's very important to do these correctly because the last thing you want to do is to do them incorrectly, because once you pass away, you're not going to be able to change these. So you can't go back and correct these if they're not done properly, unless you are living. Again, you can always change your will. If you have a will that was done 10 years ago and it was done by a friend of yours, or you did it online or something, and it doesn't meet these requirements, you can always change that as long as you're able mentally and you're still living to do that. But generally the three requirements are: it's got to be signed by the person making the documents. It's got to be signed by two witnesses, and these people actually have to literally witness you sign the document, so they have to be present. The senior law project, a lot of times we are meeting with our clients at their local senior centers around the state. And what they'll do is they'll provide volunteers that are there, or people that are just at the senior center as witnesses. And that prevents the issue of being disinterested. You don't want to get people to be witnesses that have an interest in the document. For example, if somebody's to inherit something, they're not going to be the best witness for that, to be signing it. So the best thing to do is just to get two people that are totally unrelated and have no interest at all in the will. Finally, it's got to be acknowledged by a notary at the same time as everything else is executed. The POA, the financial power of attorney, is different. It does not require the two witnesses. It only needs to be signed by the principal and to be notarized. So you don't have to have witnesses for that. And one thing about the power of attorney that I don't think I mentioned before, but it's kind of related to this: a financial power of attorney and a healthcare power of attorney, but a lot of times a financial power of attorney is where this comes up. If at some point you want to change that or revoke that, as long as you have the mental capacity to do that, you can always revoke it. There's a way to do that, and that is binding on the person, and that will immediately terminate their ability to act on that. So you're not stuck on that. I mean, there's a way to get rid of that. If somebody, and we've had cases where we've had to do that, where the person has been using it improperly, and the best thing to do to prevent that is to just revoke it and take it out of their hands. And so that can be done with a power of attorney. This last page, and then we'll be done with the presentation, is just additional resources we have. The courts, North Carolina court system has, a whole area on estates, wills and estates. Secretary of State has forms. The advanced health code directives, a lot of those are just statutory forms. They're all going to be the same. Financial power of attorneys as well. And then we've also got the general statutes on the wills, intestate, succession, and power of attorney. And then finally, we've got our legal aid number, and then our legal aid senior helpline number. Again, we're able to assist people with wills and advanced directives in some instances when they're over 60 years old.
All right, perfect. We now going to open up for questions. Again, if you have a question, you either need to type it in the Q&A box on Zoom or put it in the comments section on Facebook. You cannot unmute in this forum. And so I'm just going to get started. First question. Does the living will have the final say on medical treatment, or the person you designate with the healthcare power of attorney? So between those two, who has the final say?
Well, the living will is only going to come into a situation where you're at your end of life. So at that point, the medical decisions are going to be fairly limited, because the doctor's only going to be, he's going to make he or she's going to make the finding that you're at that end of life point. And so at that point, the decisions are going to be your living will, because it's going to outline what you want, whether you want, artificial resuscitation, things like that. The healthcare power of attorney is going to make all the other decisions until you get to that point, if that makes sense. So if you're, say you're in that car wreck and you're in a coma, but the doctor thinks you're going to come back at some point, that there's hope that you're going to survive this. Um, that would not impact your living will, would not come into place during that. Only your healthcare power of attorney would. So if the doctor had a question while you're in that coma, then he or she would ask the healthcare power of attorney what the decision is. Um, and if it got to a point where the doctor changes his decision and says there's no way you're coming back from that, then at that point they're going to look at the living will to direct them on how to deal with the end of life issues.
Perfect. For those of you asking questions about whether the PowerPoint and the video will be available, I will discuss those at the closing about let's see. Someone's asking if they move out of state, like say they made their will in North Carolina, but they're going to move out of state, would they need to make a new will in that new state?
Probably not. The states are required to recognize valid wills from other states. But from a practical standpoint, I would probably recommend doing that, because they can take different forms in different states. I mean, essentially they're the same thing legally, but it might make it easier. For instance, if you pass away in that other state, it might make it easier to have a will done in that state just for the estate process. It might make it quicker. It might make it more simple, but it's certainly not a legal requirement. But it's certainly, I would probably, just do that just to cover your bases.
Sure, this is something you can answer, so totally, if you can't answer it, no problem. Are you familiar with the Ladybird deed option? And are you willing to discuss that if you're familiar?
Yeah,
Explain what that
we
is.
at Legal Aid, this comes up a lot. We don't do those, and what that's related to, it really is not related to a will. That's a Medicaid, Medicare process where you're trying to put property out of that calculation. Um, I don't have much experience with that, and I don't feel comfortable, getting into the details of it. It's really something you need to get a private attorney to go over that with you. I will tell you, just from my experience, um, they're very popular now. A lot of attorneys are doing them. They charge a lot for them. I don't think they're needed in most of the cases that people do them in. So there's a lot of misinformation about it. So you really want to be careful, and consult and really think about that. When you meet with a private attorney. But like I said, Legal Aid, we don't do that, and the Senior Law Project does not deal with those.
Perfect. Um, is there an advantage to leaving to someone leaving their home in trust rather than having it pass in a will? Is there any advantages there?
Yeah, I mean that's the same kind of thing as the Lady Bird deed. We don't
Okay.
do trusts. People use trust for many different reasons. You can put a trust in a will. Um, again, I don't know a whole lot about that, but the advantages plus its disadvantages. To me, my personal opinion, like I said with the Lady Bird deeds, most people don't need trusts. Most people that do trust don't necessarily need them. It can complicate the whole thing if you're not needed. And I, again, we don't do those, so I don't really want to get too much into them. But I just my personal experience is, they tend to complicate things when they may not really do any good.
Perfect. I think that's the last substantive question I'm seeing at the moment. Someone's asking a question about do we do a revocable, I never know which way to say that word, trust presentation. We do not do one of those listen and learns at that time. I did put a link in the chat if you have ideas for future listen and learn presentations where you could share that. We might be able to take that on and figure out that might be something we can add. And then those of you who are asking about, they heard you say that, the Senior Law Project at Legal Aid is only for those who are 16 and over. What can they do if they're under 60? I have put a link to the North Carolina Law Referral Service, which I think is one of the resources you had on that prior page. That is a resource. ran by the North Carolina Bar Association that has private attorneys that will do a consultation with someone for about 30 minutes for about $50, if I'm remembering correctly. And one of those, you could potentially find a private attorney who might be able to assist in reviewing a will. Only other question, and this is just a question we get asked all the time. How do you feel about some of those online will and power of attorney templates and people using those?
Yeah, I know it's probably not unpopular for attorneys to say this, but I don't have a huge problem with those. They're getting better as the technology gets better. Um, just make sure, I said about the execution process, make sure you do that correctly. I think the biggest problem with those would not be the actual document and what it says, because, those are pretty standard. The big problem comes in if you're not having an attorney assisting you with actually executing it properly, with the witnesses, with the notary. And again, that's certainly something you can do yourself, but it's a massive problem if you don't do it correctly and the person's passed away, or if you don't do the power of attorney correctly and the person's incapacitated. At that point, you can't change it. So again, I don't, substantively, I don't have any problems with those. I think they work, like I said, they're getting much better. But the big issue comes when the actual execution of the document, because I don't think they're going to help you. And it also can vary state by state. So you got to be careful with that too.
Perfect. Okay. Well, since I have not seen any more questions, I'm going to go ahead and say thank you to all of you for joining us, with a special thank you to Bill for presenting and answering those questions. If you would like to review anything that Bill discussed today, we have posted a recording of today's event to our Facebook page. It will be immediately available. You can access the recording with or without a Facebook account on Legal Aid's Facebook page at any time for about the next 30 days, and then at any time in the future on Legal Aid of North Carolina's YouTube page. If you would like to register for one of our other Listen and Learn programs, such as tenant rights, child custody, fair housing, you can do so on our website at www.legalaidnc.org/clinics. Thank you all so much, and I hope everyone has a wonderful rest of their afternoon.